Welcome to Jackson Lewis's podcast, We Get Work. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every organization's mind: how will my business be impacted? To say mergers and acquisitions present significant risk is an understatement. However, additional vulnerabilities are being exposed as bad actors threaten to exploit privacy and data security leaks during the transition. On this episode of We Get Privacy for Work, we discuss what employers can do to protect client and employee data as they expand their company. Today's hosts are Damon Silver and Joe Lazzarati, co-leaders of the firm's privacy, data, and cybersecurity group, and principals, respectively, in the firm's New York City and Tampa offices. Damon and Joe, the question on everyone's mind today is: what steps should employers take before, during, and after an acquisition to minimize cybersecurity risks, and how does that impact my organization?
All right, good afternoon. Thank you, Alicia. Welcome to our We Get Privacy podcast. I'm Joe Lazzarati. I'm joined by my co-host, Damon Silver. Damon and I co-lead the Privacy, Data, and Cybersecurity group here at Jackson Lewis, and in that role, we receive a variety of questions every day from our clients, all of which boil down to the core question of how do we handle our data safely? In other words, how do we leverage all of the great things data can do for our organizations without running headfirst into a wall of legal risk? And how can we manage that risk without unnecessarily hindering our business operations?
On each episode of the podcast, Joe and I are going to talk through a common question that we're getting from our clients. And we're going to talk through it in the same way that we would with our clients, meaning with a focus on the practical. What are the legal risks? What options are available to manage those risks? And what should we be mindful of in terms of execution? So Joe, our question for today is, what are some of the data privacy and security concerns that come up if we as a business are thinking about acquiring another company?
I think there's really a lot to think about there, because you have to think about this from the standpoint of, well, what kind of data do we anticipate the target will have? I think we have to think about what industry are we in, where there might be some regulatory requirements. We might think about what type of information we want to have, what maybe we don't want to have. I think we have to think about, and we can dive into a lot of these issues, right? But, if we're going to purchase equipment from the target as part of the transaction, as part of the assets, particularly if it's an asset deal, then we can get rid of some assets, take some assets. What's the status of those? I mean, certainly don't want to buy a data breach, right? And want to understand if it's out of date, what would it cost to get it up to the standard that the company is at, right? So just understanding that. So really thinking through and making an assessment of the risks in those and other areas, I think is kind of something that, during the due diligence process, we'd want to assess pretty carefully.
Yeah, absolutely, Joe. And I think you touched on this, and maybe we can dive into it a little deeper, but there are some key questions that you want to ask to try and get your handle around the data privacy and security risks you're potentially assuming. So you mentioned one for sure, getting an understanding of the types of data, what legal obligations may attach to that data, what contractual obligations may attach to that data. I think an important one is get an understanding of the target's record retention practices. Do they have, for example, data in all of their email boxes going back 20 years? If that's the case, you probably do want to get a pretty quick understanding of what might be in those mailboxes. Probably do want to get a process in place to do some archiving and some purging, because we have seen quite a few breaches where there was an acquisition, and then the data, some of the data at least coming over in connection with the acquisition, was kept in a legacy system that wasn't actively being used, but it was just, it was there. and it perhaps had some accounts with administrative privileges, and no one was monitoring those accounts. They weren't running their normal endpoint detection solution on that environment, and it was a field day for the bad actors. They just got to go in there and take everything they wanted completely undetected until they released ransomware or took some other action that finally tipped people off that this breach was happening. And in doing the investigation and talking to clients, a lot of times it turns out that there wasn't really even a need to continue to maintain that data or to maintain most of it, but it was just sort of there. It was something that no one really wanted to spend the time to dig through, and it was this massive source of liability just sort of sitting out there. And Joe, maybe you can talk about some of the other sort of dormant liabilities you could run into. I mean, data breach is definitely one of them, but on the privacy side and from some other standpoints, there could be other types of risks that you're not aware of until you've really dug into what data set and what systems you've required.
Yeah, I think just to give a couple of examples that come to mind, sometimes employees might get copied on an email or save in a share file, a spreadsheet that has all kinds of information that may not be necessarily relevant to the business. I know in one case, in connection with an acquisition, it was learned after the acquisition that one of the employees of the acquired company had been running their personal tax business out of the company's systems. and then the company realized that they had tax returns of people they're like, what is this tax return? What's going on here, right? So they didn't know that, right? And to some degree, it may be difficult to find those hidden treasures that you wind up with, but something like that. But perhaps there's a service, right? I think we've worked with some that can run some type of a scan to identify data that might be unusual or create some unnecessary risks. That's certainly one thing. But even in the employment context, you might get, and we've run into this where the buyer will want to see what's the status of the employees, like who do we want to hire, and what's someone's work history, and how many leaves of absence do they have, and workers' comp costs. Now, we're talking about the purchase, but from the seller's perspective, they may want to say, well, wait a second, we don't want to provide that. Certainly not until the transaction closes. And what if we do want to exchange some information during that time? And you decide to do that, right? You decide to share that information. One question is, if you share the information, what are you sharing? Can you disclose that information in the due diligence process? And then if you do, what exactly are you sharing? A lot of people talk about, well, we'll give you the personnel file. Well, if you haven't had good data practices and kept files separate that ought to be kept separate, you might be sharing medical information, for example, to a party that doesn't have any authority to have that. And in effect, you may technically create a breach or a violation of, maybe the ADA or even HIPAA. So that may be like kind of a dormant issue that in the process of what might be considered a normal exchange of data in anticipation of a deal, you wind up doing that. And just by the way, for those exchanges of data that do make sense and aren't going to trigger those kinds of things, you still may want to have some kind of a due diligence agreement that covers the responsibilities for that data. You could certainly conceivable in the course of carrying out a deal, you may have a data breach, and then who's responsible for that? Or if the deal doesn't go through, what happens to the data? But those are some of just a couple of examples of some dormant issues that I've run into, Damon.
Yeah, no, I think those are important ones, and I did want to just drill down on one. It's really a good question to ask and a litmus test in some ways, and it's a topic that we talked about on a previous podcast episode, and that's data mapping. If you were going to be acquiring this company, something you want to ask about is their data maps, because one, if they don't have them, they've never done data mapping, they have no idea what that is. Like that definitely tells you something about their data practices. It suggests they do not have a very mature program. If they do have them, you can get hopefully a preview of some of these issues that we've been talking about. You can see what type of data assets they've been using to process data, see what types of data elements are being maintained by those various assets. You can see some of the safeguards that are in place. You may be able to get some information about retention practices. And so that could be a very helpful starting point to try and get a better understanding. You're never going to have a perfect understanding. There's always going to be some chance for surprise. But in looking at data maps and asking about data maps, you at least give yourself sort of the lay of the land and have put yourself in a better position to ask additional questions and to start getting a real handle on what the risk profile is of the acquisition from a data privacy and security standpoint.
Yeah, I think that's a lot. I mean, you talked about sophistication and trying to understand what the target company's approach to data privacy and security as an indicator of what the risk is. And I think that's really important. And just kind of taking that to a different level. I run in sometimes to situations that, just to use one industry as an example, like in healthcare, if you're a hospital system and you're acquiring a practice of physicians, you may acquire them in whatever form that takes. The physician practice group may just be used to practicing in, let's call it a less secure environment without some controls that may be viewed as inhibiting the ability to practice efficiently, but in fact may, provide better safeguards for patient and employee data. And so after the transaction closes, and maybe they're now a subsidiary, a wholly owned sub of the acquiring company, how do you now integrate them and avoid them from creating additional risk should there be some compromise down the road because they've kind of dragged their feet in taking steps to secure their environment in a way that's consistent with the overall the overall enterprise. So to kind of thinking about that in the deal and trying to do what you can to get some assurances that that's going to take place might be a good thing, because there have been some situations where, not just in healthcare but in others, that the target then after the transaction now becomes a pretty big liability for the company overall. So understanding the overall sophistication and how to integrate the new company into the organization, can come with some challenges, not just at the transaction stage, but even afterwards.
Yeah, and one other thing to consider, Joe, is that most organizations at this point are using a variety of vendors to process their data. So it's not just the systems of the target you need to think about. You also need to get an understanding of what other parties out there are processing data that you as the acquirer are now going to be the owner of. There may be a variety of different software providers and contractors and others who may have either access to or may even be maintaining data that you are now going to own. And it's helpful to get a sense of what kind of vetting was done of those parties. Are there data processing agreements in place with them? What kind of risk what kind of vendor risk are you inheriting if you acquire this company? And sort of tangentially related to that, an issue that I've seen come up a couple of times is that one of the assets that the acquirer will acquire is a website. And that website might be running all types of tracking technologies, cookies and pixels, et cetera, that potentially if efforts haven't been made to provide proper notice and collect consent, could expose the acquiring company to claims of wiretap violations and invasion of privacy violations. And it may be a type of situation where the acquiring company has done some work on its own sites. It has an understanding of what's being run, and it has a pretty good program in place to address compliance. But that may not necessarily be the case for the new website. And I've certainly seen situations where there was a lag in taking a look at risk related to the new website, or there was just no plan to even do that. It just wasn't something on the checklist. So particularly, since over the last 2 years, we've seen so many of these website tracking type claims being brought. that's another item I think is important to try and take a look at. And because a website is public facing, it's something that, the acquiring company could even do on their own as part of diligence. They can run scans, see what's running on the site, take a look at the site. Is there a cookie banner? How's the privacy policy look? There are some self-help type steps that could be taken to get a general feel for what type of website compliance related risk might be assumed.
So you don't think you could just copy and paste the acquiring company's privacy policy and put it on target companies if they remain an entity?
I think that's the best practice now, Joe.
Okay.
You don't recommend that?
No, I mean, I think that's a great point. Even if there's not tracking technologies and pixels on the site, I think you're exactly right to be looking at that, because even the internal practices that now these comprehensive privacy laws that you're referring to are obligating companies to really delve into. Well, what are you collecting, and what are you disclosing, and to whom? What are the sources of the data? What are your rights? And that can get pretty confusing pretty quickly when two organizations come together and have pretty different practices as it relates to that. So I think that's a really good point. I think in any transactions attorney's toolbox, they probably may not deal with these issues all the time, and they may want to have some specific counsel, whether it's internal or at the company or otherwise, to kind of really dig into this. Because I know even for a lot of vendor contracts and some of the deal documents we've looked at, the data privacy and security provisions have gotten a lot longer and a lot more complex, and it really is a lot to dig into. So we've just kind of scratched the surface here. I don't know, Damon, did you have any other things to kind of raise, at least at a high level here?
No, Joe, I think that's a really good place for us to wrap up. So we want to thank everyone for joining us on this episode of the We Get Privacy podcast. As always, if you have any suggestions for topics we can talk about, any feedback on this episode, please reach out to us at privacy@jacksonlewis.com. Thanks, Joe.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help organizations develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.